Good morning to all participants in this webinar. My name is Jonathan Goldsmith from the European Lawyers Foundation. We have a lot of people joining us this morning, and so I will begin by making a number of announcements related to the webinar. So this is the webinar organized by the European Lawyers Foundation and the Council of Bars and Law Societies of Europe on anti-money laundering for lawyers, the new EU AML package, and general practical advice. We have a lot of people joining us this morning for this webinar, and so here are the announcements. First of all, you will see at the bottom of your screen a question and answer box, and it is there that we would like you all to put your questions to the speakers in English. Please do not use the chat box for questions. They won't be answered there. There's a specific box for question and answers. Put them there in English. And as time allows, at the end of each session, we will put questions to the speakers. We're very happy if you use the chat box to present yourselves or to communicate with other participants. We'll try to answer all the questions, but some may go unanswered because of our large audience. This webinar is being recorded, and the recording will be available on the European Lawyers Foundation's website. This webinar is all in English and no interpretation is provided. There are two very important points to make, and number one is this, is that as the presentations go forward, many people ask us, will they be available to you? Yes, all the presentations will be uploaded on the website of the European Lawyers Foundation. The presentations are packed with extremely useful detail, and we do want you to see them. So they won't be sent to you individually, but they will be able to be consulted on the website of the European Lawyers Foundation. Number two, a number of you may need certificates for attending this training. The thing to understand is that we at the European Lawyers Foundation do not provide certificates. You need to approach your own bar, tell them that you have been on this training. They will then approach us and we will let them know the time that you participated in this training. So please approach your bar for the training certificates, not us. Right, we're now ready to begin the webinar in earnest, and it's my great pleasure to introduce Dominique Attias, who is the chair of the board of directors of the European Lawyers Foundation. She's from France, who will make some introductory remarks. Dominique, over to you.
Thank you very much. Thank you very much. You listen to my accent, and you know I am from France, huh? Okay? Dear colleagues, it's a very good pleasure to welcome all of you to this second webinar on anti-money laundering, organized by the European Lawyers Foundation and the Council of Bars and Law Societies of Europe. The organization of this webinar is due to the great success of a very similar webinar on this topic that we held on 26 February 2024. The interest was so large then that more lawyers registered than places were available. And so a considerable number of lawyers could not participate. We know that there was some frustration about the limits of on places, and we apologized for the inconvenience. But now you are nearly 2,000 in this webinar from all the bars of Europe. It's a great success, and I can tell you that, and a lot of lawyers who wanted to come in this webinar, and we have no more places. Today's webinar is an exact repeat on the webinar we held last February. So if you could not participate then, no worries. You are going to see is today it's a marvelous seminar. You will see the same presentation and today and as you would have done in February. For those who have registered for the first time, I can promise you excellent speakers and super excellent slides. Before giving the floor of the moderator and to the speakers, I want to express my gratitude to all the participants for their trust in attending today. I also want to thank the speakers, thank you all of you, for their availability. Finally, I want to thank the Council of Bars and Law Society of Europe for co-organizing with webinar with a European Lawyers Foundation. This webinar is co-financed by the European Union, and without their support, seminars such as this one would not be possible. We will organize more free of charge webinar in 2024, so I encourage you to follow the European Lawyers Foundation on LinkedIn and X Twitter to stay tuned. Thank you all. Thank you also for my dear Jonathan. Thank you also, Vasily, who are here. And thank you all of you, and have a very good training. Thank you very much.
Thank you, Dominique. Thank you. And we now move on to the first substantive session, and that is on the European Union's new anti-money laundering package. And we will have two presenters for this. First of all, we have a presentation from the European Commission, which is a general presentation of the upcoming changes which will be introduced because of the new package. And for that, our speaker will be Constance Deshonnette, who is a policy officer at the European Commission at the DG, the Directorate General, which deals with anti-money laundering. And once she has finished speaking, we will have someone who will look at the key changes introduced for lawyers, and that will be Claudio Cocuzza, who's an Italian lawyer, member of the Milan Bar, and he is chair of the CCBE's Anti-Money Laundering Committee and a member of the Anti-Money Laundering Committee of the Italian National Bar. So, Constance, over to you for your presentation of the upcoming changes through the new AML package. Thank you.
Yes. Good morning, everyone. Normally, my screen is shared.
Yes, it is.
Okay, perfect. Okay, so good morning, everyone. I'm very pleased to be there, and I like to say that I'm really delighted to see that again so many people are there attending this event, that show really the interest that you have in that topic of combating money laundering and terrorism financing, and therefore the new AML package, which has been adopted just last month. So as Jonathan say, Claudio Cocuzza and I split up the presentation. I will deliver to you a very general presentation on the whole package, that means on the 4 texts that made up this package, and Claudio will follow up with a more specific presentation on the non-financial sector. So that's also the reason why I will start now with my presentation. So firstly, let me give you an overlook of the timelines. So in July 2021, the European Commission issued a package of 4 legislative proposals to overhaul the current AML CFT framework in the EU. The negotiating process with the co-legislator lasted more than 2 years, but it was possible to reach an agreement on all texts between December 2023 and February 2024, as well as the location of the seat of the new European authority in charge of combating money laundering and financing of terrorism. We call AMLA, and it will be located in Frankfurt. Final adoption took place in the European Parliament in April 2024. So what is the package? So as I say many times, it's made up of 4 legislative proposals. The first element is the new regulation. This is a very ambitious leap as we are setting up directly applicable rules toward obliged entity. That means that the private sector will implement the same rules no matter where they are based in the European Union. Secondly, we have a new AML directive, the 6th AML directive. This covers rules which are intended for public authorities. The idea is there to leave some room, because it's a directive and you perfectly know there is a margin of transposition, so room for member states to decide how they wish to structure the AML system, including the functioning of national supervision and cooperation, but as well as the organization of the financial intelligence unit. A bit apart, there is the recast of transfer of fund regulation. We are extending here the rules to the crypto assets. And fourth, and finally, and maybe the one that attracts a lot of attention, is the new European Anti-Money Laundering Authority, or AMLA, whose mandate is set out in a specific regulation. This new authority, as I say in introduction, will be located in Frankfurt in Germany, and this has been the outcome of a joint vote of the 2 co-legislators. So let's start with what we call the single rule book, which is made of 3 texts. One is already adopted and published. It's a recast of the transfer of fund regulation. For the 2 others, so the AML regulation and the AML directive, they have been adopted by the co-legislator, but not published yet. Sorry. So very briefly on this recast. So this recast extends the scope of the TFR to transfer in crypto assets. Here we are aligning the European legislation with the FATF work on the travel rule. More concretely, full information of originator and of the beneficiary have to be included by CAS with all the transfers of crypto payment, just like PSP are currently doing with wire transfer. In terms of timelines, this text is decoupled from the rest of the package. It has been negotiated earlier and will be entered into force in June, has been entered into force in June 2023, but will start to apply in December this year. Let's now focus on the 2 other legs of the single rule book, so the AML directive and the AML regulation. So how do you know which rules are contained in which text? So it's very easy. The key distribution of the rules contained in 2 texts has been made according to the addressees of the rules. On the one hand, the rule for the private sector, so the so-called obliged entity must apply, will be set out in the directly applicable regulation. On the other hand, the rule for public authorities are in the directive. And you can see on this slide the topics that cover by each text. So if we now focus on the AML regulation, so the rule for the obliged entity. So firstly, co-legislators have decided to subject new entities, new profession to the AML requirements. Among the new obliged entities, the main novelty are, for instance, full boat club and agent, but also trader in high-value goods such as jewelers, horologists, and trader in high-value goods, like, for instance, boats or planes. As regard customer due diligence, again, I will only go through the main novelties. So new occasional transaction tracer have been inserted, as you can see on the slide, including for cash transaction above 3,000 euros. The rule related to simplify and enhance due diligence have been specified and therefore harmonized. Co-legislator also inserted rule for preventing de-risking by adding the obligation to record steps taken when onboarding or rejecting a client. And you have also to keep in mind that most of those rules will be completed by technical standards. So, and they have to be completed for mid-2027. As regard now to beneficiary ownership, so IMLD5 lacked granularity, which led to different methods of identifying the BO and an inconsistent way of calculating the thresholds. So now, with this new regulation, we have inserted more detailed and harmonized rules, and that, for instance, will clarify the type of information needed to be collected to identify the beneficial owner, and also will give a very detailed calculation rules for corporate entity and other categories. The general threshold for ownership is kept at 25%. However, the European Commission, is empowered by the co-legislator to identify categories or activities of entities that pose higher risk and for which a lawyer's threshold will be justified. However, this threshold is firm. It cannot be higher than 15%. Another interest element is the requirement to register beneficial ownership information of foreign legal entity in specific circumstances where there is, for instance, an interaction with the internal markets. We can, for instance, quote the example when an entity just want to purchase real estate or in the European Union. Another big novelty of the package is the inclusion of a limitation on the use of large amount of cash necessary to prevent some money laundering. This limitation is of 10,000 euros. I've been also inserting obligation of reporting to the FIUs, but this obligation is just for credit institution and financial institution for the deposit or payment of 10,000 euros. So here, it's a really big and quick overview of the AML regulation, but to conclude on this text, the idea here is that anywhere in the single market, the same activities that carry the same risk will follow the same rules. Now let's move to the other leg of the rule book, which is the directive. And sorry to repeat myself, but I'm sure we will remember this information. But the new directive is addressed to member states, not to obliged entity, and more specifically to public authority with the view of organizing the supervision of the obliged entity and the activities of the financial intelligence unit. So as regards the supervision, the main novelty are firstly, that the directive will provide a common framework for the power to impose pecuniary sanction and administrative measure. As you probably know, the disparity between member states was one of the, I think, major weaknesses of our current European framework. And also, again, this framework will be then complemented by technical standards. Another point which is important is the AML directive will give a legal basis for the AML supervisory colleges, and those colleges will be organized in both sectors, the financial sector and the non-financial sector. For the financial sector, it was already the case. The legal basis was the article on cooperation in the current directive and was also based on EBA guidance, but it's really a novelty for the non-financial sector. But contrary to the financial sector, where this obligation is mandatory, for the non-financial sector, it will be only a possibility. Another point that should interest you is that we have introduced in the directive a public oversight over the self-regulatory bodies, which are for the legal profession, often the Bar Association. But to be very clear here, because it's often a point of concern when I have to present this point in front of lawyer, the aim of this new layer of supervision is in no way to replace the SRBs, and therefore it's no way for this authority to have access to lawyer files. It's simply for this authority to check that the SRB in charge of supervision are really carrying out the supervisory activity properly. But we can come back later, and I know that Claudia will make a focus on that. As regard now to the FIUs, so if I have to mention only one point, which is really a novelty, is that the AML directive will give a legal basis to organize joint analysis by European FIU. That means, for instance, that the Belgian and the Italian FIU will be able to conduct together common analysis. So it's go beyond just cooperation. The AMLD also provides a framework for setting up registers. So as regards the beneficial ownership register, AMLD increase the power of the entity in charge of those registers, and they will be able to verify the accuracy of the information submitted, including by doing on-site checks and imposing sanctions. As regards the bank account register, we have proposed to interconnect them so that the FIU can access to the information held in those registers. In the same vein, the co-legislator have proposed to set up a single digital access point for FIU and competent authority to access information on real estate. This is not really a register or database, it's really about making access to data easier and more efficient, particularly where it's held in several databases or by several people. So that will be my presentation on the single rule book, and maybe we can just move to the AML authority and the dedicated regulation. So this new authority will really become the center of the new AML European system, and will have, if I can say that, two hats. So on the one hand, AMLA will be the heart of the AML supervision. Therefore, it will have direct and indirect supervisory power on obliged entity, but only on the financial sector. For the non-financial sector, AMLA will just have coordination power. On the other hand, AMLA will be in charge for the coordination and support mechanism for the European FIUs, meaning, for instance, that AMLA will be able to launch and to coordinate the joint analysis that I just mentioned. Here in this slide, you can see the powers and tools that AMLA will have for the whole AML supervisory system, meaning for the financial and the non-financial sector. I cannot detail all the power, but for instance, AMLA will have to draft a supervisory methodology, a handbook, like it exists in the SSM. AMLA will also carry out thematic reviews at EBA already does currently in the financial sector. And AMLA will, for instance, also be in charge of an enriched database, enriched compare to the current Eureka database that EBA has developed. This slide shows the scope and delimitation of the three types of supervisory powers that AMLA will have. So for the financial sector, AMLA will be tasked of direct supervision only on some of the riskiest financial obliged entity and which operate in at least 6 member states. So the riskiest entity, of course, we talk about the AML risk. Those selected and obliged entity will be 40 as of the first selection batch. But then it will be possible, as of the second selection process, to increase the number of directly supervised obliged entity. For the other obliged entity of the financial sector, really the very big majority of the financial sector, and AMLA will only have indirect supervisory power. And for the non-financial sector, as I said previously, AMLA will only have oversight power. On this slide, we can see AMLA's power as regards the financial sector. So for the selected obliged entity for direct supervision, AMLA power are the same than the current national authority have in that sector. So AMLA will be able to do off-site, on-site inspection, and to impose sanction. As far as concerned the indirect supervision of the financial sector, AMLA will have several type of power, but maybe I can just focus on two. The first is the assessment of the state of the supervisory conventions. For this power, AMLA will assess the supervisory practices of national supervisor. For instance, what type of tool, what type of resources, and for how they implement the handbook that I mentioned previously. There will also be the possibility for AMLA to ask of the transfer of a non-selected obliged entity to the direct supervision of AMLA in case of exceptional circumstances that may, for instance, that the AMLA has an indication that the entity is really systematically not complying with a CFT obligation. This power is what we call the request to act in exceptional circumstances. Now, let's move to the oversight of the non-financial sector. For the non-financial sector, AMLA will have only oversight role. As it's a matter that have interest to you, let's go maybe a bit more in detail of the 4 powers of AMLA in this area. So firstly, AMLA will be able to conduct peer reviews over the non-financial supervisor and the public authority oversight SRBs. So, but just to precise that SRB could participate to those peer review, but just on a voluntary basis. Second power, AMLA will have the possibility to launch alleged procedure of breach of union law. Here, the co-legislator have introduced the sole possibility for AMLA to issue a non-binding warning toward the non-financial sector if the non-financial sector is in breach with the European law. In case of disagreement between a non-financial supervisor, AMLA will be able to mediate between the two non-financial supervisor. But contrary to AMLA's power in the financial sector, this opinion of AMLA will be not binding. And finally, AMLA will be tasked to coordinate and facilitate these new AML supervisory colleges in the non-financial sector. As regards quickly FIU and the power that AMLA will have, so as I say, the big novelty is that it will be able for AMLA to initiate, to coordinate, and to help FIU to do together joint analysis. And now my last slide will be on the timeline of the application of this package and on the, of the task of AMLA. So the package will be probably published in the official journal of the European Union in June, so next month. When the package is published on the official journal, AMLA will enter into force 7 days later. I'm sorry, it's written 20 days, but it has been a change of last minute just before the adoption. It would be 7 days. But that do not mean that AMLA will be able to accomplish all the tasks from the outset. First and foremost, AMLA will have to draft several so-called level 2 and 3 measures that the regulatory technical standard and guidelines that specify the provision, and that's and those level 2 and 3 measure has to be drafted for mid-2027, and that will really fully finalize the AML package. From mid-2025, most of the articles of the AMLA regulation will be applicable, and AMLA will be then, for instance, able to carry out horizontal tasks such as thematic review, mutual assistance, convergence assessment, as well as, for instance, to set up colleges, to help to set up colleges. But the direct supervision would only start for the financial sector as of 2028. The AML regulation and the AML directive will begin to apply 3 years after the publication, so 3 years after probably June 2024. So probably all the package will enter into force in 2027. So I hope I haven't been too long, and overall I have been understandable. So I will now pass the floor to Claudio, and I will be happy to answer all your questions you may have after his presentation.
Very good. Thank you very much, Constance. There are already questions, and Claudio, you ready to go?
Well, thank you very much, first of all, Constance, for the very clear and comprehensive presentation. It gives us an overview of what's going on, of what has happened, and of the next steps that we have to monitor and look after.
Can you make your slides full screen, Claudio, if possible?
I'm trying, yes.
Thank you.
They should be full screen now.
Perfect, yeah. Perfect.
Of course, I would try to give the perspective of the legal profession. We as CCBE, first of all, have been following, monitoring, discussing, interacting with the European Union players, and in the final part during the trilogue, in a very interesting exchange with the various actors of the European legislation. And we learned a lot. We learned a lot because we have been really disseminating and trying to learn from what the European institution wanted to achieve, and make sure and try to make sure to let out a message of what we do, how we do it, and what is our role in terms of anti-money laundering. The legal profession has been present in this effort since the beginning of the implementation of the directives, and is playing an important role in terms of awareness of the problem, in terms of efforts of disseminating knowledge and culture of anti-money laundering, in terms of efforts of vigilance and supervisions by the bars. Incidentally, just recently, the CCBE has adopted a paper that I believe will become available soon on the AML supervision and practices by bars, who provides information on what we do in terms of supervision of lawyers when it comes to their compliance with anti-money laundering. What have we learned during this process? Well, we've learned that that is not always easy to make the legislators understand exactly the importance of certain elements in terms of the specificity of the legal profession when it comes to two elements. One is independence of lawyers, and the other one is the protection of the legal privilege. And these are two cornerstones of what we do and what we are. And we have thought during the process to make sure that these two cornerstones were, as much as possible, safeguarded, protected. And certainly not for us, because these milestones are not there for us, but these milestones and shields are there for the citizens. It is for the citizens that the shield of legal protection and legal privilege exists, and it's for the citizens that independence of lawyers is protected. So today, I will really try to answer three questions when it comes to the package. The first question pertains to the AML regulation that Constance has briefly described, and I will focus on Article 70 of the AML regulation. I'd like to respond to the question as to whether the exemption for lawyers from reporting obligations has changed, and if so, to what extent. So this is the first question. The second question goes into the new AML directive, and I'd like to explain and discuss with you as to what extent the oversight of self-regulatory bodies maintains or protects or is aware of the independence of lawyer and to what extent this is protected during this oversight. The third question is a very specific issue regarding the powers of AMLA, the anti-money laundering authority, and covering Article 37, the new Article 37 of the regulation establishing AMLA. So let's go. So three questions, three issues, try to go directly in the heart of the matters. I will be, try to be quick and try to provide you as much clean and significant information as I can. Turning on, first of all, let's switch off the phone, so it doesn't bother anybody. I apologize. Article 70, the provisions regarding reporting of suspicion by certain categories of obliged entities, i.e. lawyers. As we all know, the lawyers have been granted an exemption when it comes to making and filing STR, suspicious transaction reports. The exemption and the perimeter of the exemption is phrased in Article 70, second paragraph. First question is, has it changed vis-a-vis the previous legislation? And the answer is no. The hardcore of the exemption is there. And in fact, if we read it, it is clear from the text that it is the exact wording as before. So lawyers are exempted from STRs to the extent that the exemption relates to the information that they receive in the course of the ascertaining of the legal position of the client, first angle, and in the course of the task of defending or representing the client in court, etc. So the perimeter of the exemption for us is the same. It hasn't changed. During the course of the trilogue, it's been various approaches to this were given. different wordings, different angles. The approach of the European institution, I must say this, loudly and clearly, has been the way of not really wanting to. The approach is trying to make sure that lawyers would correctly behave, which we hope we do all the time. But secondly, the angle has been in certain instances in the way of shrinking the exemption. The idea behind basically was to try to reduce the exemption, which was seeing something in favor of lawyers. This was a mistake. This is a mistake. But however, as I'm saying, this has not changed. Now, the changes is in the following paragraph. However, the changes is basically an exception to the exemption. And the exception to the exemption is listed in the letters A, B, C, which you see on the screen. Now, I will not get into that directly. I just simply, share with you the thought that this exemption to the exception are not really relevant for us. Why? Because basically the perimeter that they're offering is a description in situation in which lawyers take part in money laundering or provide legal advice for the purpose of money laundering or know that the client is seeking advice for money laundering. Now, clearly, these three situations show us two things. One, that sometimes European institutions mixed situation and confounds very simple legal issues. Because here is not a situation in which a lawyer unwittingly is abused and used by criminals for them to pursue their actions, with the lawyers not being aware of what they're doing, which is the purpose of AML. Suspicious, it comes in a situation in which lawyers are encounters bad guys and need to signal them in certain specific situations. Very clear, with red flags and so on. Now, so that is the purpose of AML package and AML legislation. Now, this exemption clearly indicates lawyers who are committing, crimes. Because being aware of a party, of a client doing money laundering, take part in money laundering, or provide specific assistance knowing that the purpose of the client is to launder money is a crime. So clearly, lawyers cannot be exempted from making an STRs. Those lawyers, those professionals, those notaries, those, so in my opinion, and in the opinion of the European the AML Commission, this exemption from the this exception from the exemption for lawyers to make the STRs doesn't change things, because certainly it describes something which is not a concern about. The third paragraph, however, concerns us, because the third paragraph introduces a situation in which member states may decide that the exemption, the one that I have described, the criminal law exemption, let me describe it in this way, does not apply to those type of transactions, and as appropriate, impose additional reporting obligations on lawyers, on the obliged entities. Member states must notify the Commission of any decision, etc. I am confused. I've always studied and learned that regulations needed to provide full specific harmonization, equal provisions for everyone throughout the European Union. And here we discover a situation in which member states may once again modulate this very delicate situation differently from one state from another. We are strongly in opposition of this provision. We find it irrational. We find it against the purpose of harmonization and of clear provisions for every lawyer around and throughout the European Union. So we will be vigilant, and we will be, of course, look into the application of this third paragraph of Article 70. Yes, Constance will remind us that there is a whereas clause in the regulation, is whereas clause 143, that to a certain extent reduces the discretionary power of member states when it comes to adopting this further exemptions. I will not get into this whereas clause. Of course, the whereas clause cites proportionality, cites human rights, cites the bulk of certain constitutional elements. But the point is, and the problem is, that this discretion is there, and it might be then in a few years down the road in which once again we will have different situations, different provisions, and different legislation for lawyers throughout Europe when it comes to this very delicate thing, and we do not like this. Let me, in the last 10 minutes, address the other question, which is...
Can I just stop you just to say, could you make it 5 minutes? There are questions, and we should stop at about 45.
I have, yes, I have, on my watch, I have 8 minutes, Jonathan. Do I have those?
That's until the end of the session, but not until...
Okay, good. Very quickly, let's cover the directive and Article 52. Oversight of self-regulatory bodies. This was cited by Constance. And point is, colleagues, that we have tried to make the European Union institution understand how relevant is independence when it comes to the role of the lawyer in society. When we have, so the battle of fighting for a full-fledged, total, untouched independence by of lawyers within European Union is lost. We need to say that clearly, and it is lost to the extent that the Article 52 of the new AML directive clearly indicates that when member states ensure that the self-regulatory bodies, so the local bodies, are granted rights to oversee and to oversight the activities of the lawyers, are themselves controlled, are themselves put under an area of oversight. We, of course, have, in the course of the dialogue with the European institutions, clarified that this oversight would need to be provided in an indication and in the direction that the self-regulatory bodies will need to continue to perform their functions free of undue influence, that confidentiality and confidentiality of information need to be protected, and that, of course, the authority exercising the vigilance would need to maintain high professional standards of both confidentiality and data protection. All these elements are indeed contained in Article 52, which therefore strikes a balance of the two entities, whereas the controlled entity is indeed controlled. There is a vigilance, but there are some elements to balance the powers of the supervising authority. Last point, in the last 2 minutes, I will try to answer the question as to the Article 37 of the AMLA regulation, because not only the public authority will oversight bars when it comes to their actions in vigilance, but also the AMLA authority will do that. When they will do that, when AMLA has grounds to suspect that that the SDR is breaching union law, and when there is grounds to suspect that this happens. Of course, we don't necessarily like this wording, because it seems to me, as vague as our suspiciousness when it comes to money launderers. But the Article 7 declines itself in a direction in which basically at the end, the AMLA authority can issue warnings on breaches by the SDRs. And the point is that the position of ours and of the Commission is that these warnings are non-binding. So this is correct interpretation. But certainly the structure of the provision is that it appears that some other people could, or judges could, interpret the warning as being binding, because it's a very strict language.
We must stop, because really there are a lot of questions. And one of them is on supervision by AMLA anyway. Peter Golob, thank you very much, Claudia. Sorry to stop you, but only because there are quite a few questions. So for both you and Constance, Peter Golob has said, is there any plan for a pan-EU ultimate beneficial ownership register that is available to all and harmonizes data between the countries so that we can easily do know your client checks? Who wants to answer that?
Maybe I can go. And their answer is yes. That's a project. Okay, there is a project to interconnect ultimate beneficial ownership register for all member states. This project is named Boris, and we have started to interconnect the BO register since years, I think 2 years. Now it's a super heavy project from an IT perspective, notably. So we are facing, of course, challenges to finalize it, but we know that almost 6 countries already are interconnected between each other. And as an obliged entity, as lawyer and obliged entity, will have access to the beneficial ownership, this interconnection of beneficial ownership register. But maybe I can find a link to this project and just answer you in the chat.
That will be very helpful. Thank you, Constance. This ties into the point you were making, Claudio, about the supervision by the... so it says, currently the supervision of financial institutions is done by a national supervisory authority like a national bank. Once AMLA takes over the supervision, does that mean the national bank will pass those functions to AMLA, or their share supervision, but AMLA will have the last say? Will they cooperate, and how will that work? Who wants to answer that?
I think it's for me because it's financial sector.
Yes, financial.
Okay. Okay, how will be this direct supervision? I think if I sum up the question. Okay, it's exactly like we have in the SSM for the prudential risk. That means that when an entity has been selected for the direct supervision, it will be set up what we call joint supervisory team. It's team mixed by national supervisor and AMLA. That means that it will be permanent link between the national supervisor and AMLA for the direct supervision. So of course, the coordination between the national supervisor and AMLA will still be there and reinforced in a way.
Thank you. Thank you for being quick. Duca Levinson asks, maybe this is for you, Claudia, has asked, is the exemption for notaries and lawyers applicable to the settling of an estate?
To the settling?
In other words, I understand that to be the administration of an estate. In other words, if somebody's died and you are running the administration of estate, how does that apply? If nobody knows the answer to that, don't worry.
Well, I believe that, the exemption is around 2 areas, as I said, and it's very clear. One is the pre-litigation and litigation area. So settling of an estate, it does not appear to be in the situation. And the first and the second one is legal ascertaining of the legal position of the client. So the answer is, I believe it is not, that we are not within there, within the exemption area.
Thank you, thank you. Last question that we've got time for from Sylvia Uskov is, what is your opinion on the fact that nowadays the law in Romania mandates lawyers to report under the AML directly to an authority of this state and not to the Lawyers Bar Association, taking into consideration Michaud against France, the European Court of Human Rights case law, where it wasn't a violation if the lawyer reported to the Lawyers Association in France and not directly to the state.
Maybe I can.
This is, I'm sorry.
No, it's just a possibility for a member state to have this intermediary. So,
Correct.
and it will be the same for in the new regulation. So, I will not pronounce myself on if the transposition is good or not, but it's a possibility, not mandatory.
I mean, Romania, like Italy, has decided not to use the filter, not to appoint the local national bar authority as a filter. And this is a political decision, and this is what it is.
Perfect. Perfect. Thank you, Claudia. Sorry to have interrupted you. Thank you both, Constance and Claudia, for your excellent answers and excellent presentations. We should move on so we don't lose time to our next session, which is called Complying with Anti-Money Laundering Obligations, Practical Advice for Law Firms and Sole Practitioners. The speaker is Emma Jane Williams, Policy Manager for Money Laundering or Anti-Money Laundering at the Law Society of Ireland. The Law Society of Ireland is the relevant body. She specialises in AML and lawyers across a whole range of policy development and guidance, and represents the Law Society in various national AML bodies, and is a member of the CCBE's AML committee. Emma Jane, over to you.
Thanks very much, Jonathan. It's really an honour to be invited to speak today. It's a fabulous conference theme, and I've learned so much already about the AML package from the speakers already today. I'm going to take a step away from that new package and provide some practical advice to lawyers navigating lawyer AML as it stands. As we know, the package will not make substantive changes to AML duties. The duties will actually be embedded or elevated in a sense from a directive to a regulation, but they aren't changing. The big changes are in terms of supervision, as we've already heard, at national and supranational level, and that will have an impact across all smaller operations. And I'm going to talk about duties which apply to you now in a practical sense, and I'm talking about the fourth directive on money laundering essentially, and the changes that were introduced now quite a little while ago. The tick-the-box approach to AML compliance is gone. All those types of features were removed, moving all obliged entities to the risk-based approach. And when I hear a question sometimes of what documents might be needed for a specific kind or a specific type of legal service, I can worry that the risk-based approach is perhaps not fully understood, because the CDD itself, the due diligence, has to be risk appropriate and not formulaic or tick the box. There is never a one-size-fits-all answer. And risk assessments are embedded not only in the business risk assessment, but on a customer and a matter level too, the instructions that your client gives you. So CDD itself is linked to risk. Your customer risk assessment must be used to determine what CDD is to be applied. And it's not just about your CDD, your policies, controls and procedures are also linked to risk. For lawyers, these requirements are not something that are coming down the track. They are very well established now across the EU, and legal sector regulators are supervising and enforcing compliance with these duties as we speak. These will in the future, however, be in the new regulation, the rule book. With that in mind, here are some questions which I hope will be of help to you in getting AML ready now, especially if you are a small firm or sole practitioner or someone who might be looking at AML compliance for the first time, a form of 10-point checklist. Just move to the next slide. There we go. So the first question to ask yourself in that AML compliance checklist is, do you have a good understanding of what is actually at stake? I think there's no harm in emphasizing that there is much more than AML compliance failure at stake. AML by its nature is there to prevent money laundering. And if you do get it wrong, the repercussions extend beyond AML compliance failure, beyond your supervisor checking your AML and finding something wrong, because there is that risk of potentially participating in the offence of money laundering. And there is a harmonised definition of money laundering now across the EU. It's been a potential in Ireland for a long time, and we have a very broad definition of the offence of money laundering in Ireland. The knowledge thresholds are low, and the offence encompasses the proceeds of all crime. And the offence can attract a sentence of up to 14 years imprisonment in Ireland. And if something goes wrong on the AML compliance or money laundering risk front, there is the risk of reputation and livelihood damage. This underscores, I think, the importance of using AML to prevent more than just AML compliance. And I think it brings us back to the importance of looking at your AML strategically and in a risk-based way. There is a huge benefit in setting aside that narrative. We can sometimes hear that AML is overburdensome if it helps small sectors and small firms to remove or reduce the risk of unwittingly being used to launder. AML instead can be perceived as an opportunity when so much is personally at stake. The second item on the checklist is to ask yourself whether you are accessing key AML resources and are you up to date on the latest developments. There are wonderful AML resources available to you which are tailored to lawyer AML. While so much can be learned from resources for other sectors, I personally believe that the greatest impact in terms of AML compliance effectiveness can be achieved by practical sectoral guidance. So I would encourage you to visit www.amlforlawyers.eu, and they have a wonderful suite of resources available to lawyers across Europe. These resources have been hugely successful with overwhelmingly positive feedback and engagement online. This was actually a project awarded by DG Justice to a consortium composed of the two organisations of lawyers working at EU level, namely the European Lawyers Foundation and the CCBE. The user manual in particular contains everything you need to know about AML as it affects the legal profession, available also in many different languages. 3 videos are also available, each of approximately 3 hours in French and English, and they are from webinars that were hosted in 2021. I'd recommend also that you look at national guidance relevant to your sector to ensure you're complying with your supervisor's guidance. And they also tend to have very, very good practical know-how in them relevant to individual member states and how law is practiced and the best way of applying AML to that legal practice. And it's certainly important, at least for the time being, while the rulebook and any possible future AML direction or guidance evolves, to make sure that you look at amlforlawyers.eu and also at your own supervisor's guidance. The third item on the checklist is to consider whether you're up to date on sanctions. So I want to sidestep away from AML just for the moment. Please, when you're thinking about anti-money laundering and looking at the resources, do not forget to consider sanctions. It's a criminal offence also to fail to comply with sanctions. And there's links on this slide to 3 resources which I hope might be of assistance to you. The European Commission's dedicated sanctions webpage, there's a link there. The European Council's infographic is also excellent. And the Law Society of Ireland, rapidly responding to the introduction of sanctions on Russia over Ukraine, introduced a new sanctions resource hub, which you're also welcome to visit. The hub is accessible by visiting www.lawsociety.ie/sanctions, and it contains information and helpful resources to assist lawyers in ensuring that they comply with sanctions. And these steps have been designed to help, in particular, sole practitioners and small to medium firms. No AML compliance programme or strategy would be complete at this stage without detailed sanctions assessment and policies. And the legal profession also need to be extra alert due to the risk that countries and people subject to sanctions may start looking for ways to move assets or avoid sanctions. and lawyers should make compliance with sanctions a top priority. Sanctions evasion typologies is a good segue back to money laundering risk. And the fourth item on the checklist is to consider, do you understand how professional money launderers might target you and your firm? And I think this is possibly one of the most important items on this 10-point checklist. I always place an emphasis on the importance of expanding your knowledge of legal sector risk. And this is because developing a good understanding of legal sector money laundering risk is vital to adopting the risk-based approach, to preventing money laundering, and also ensuring effective AML compliance. It is so very important to understand how lawyers can be used to launder money. You can't really do AML. You can't be AML compliant if you don't know how the services you provide might be vulnerable, or if you don't know the red flags to be on the lookout for. As a starting place, it's helpful to know how law firms can be attractive to professional money launderers. And it's interesting to look at how lawyers are vulnerable during all of the three individual stages in what we now know is a three-step process which describes what money laundering is. So in terms of the placement stage, this can happen if a client arrives at a lawyer's office with cash, perhaps to purchase property for themselves. It's possible also that somebody else helping a client might arrive at a lawyer's office with a significant amount of cash. The other way of laundering money is by layering, and this can happen where a client instructs a lawyer, for example, in a fraudulent debt collection or sham litigation. The other way is through integration, and this can happen when a client may be selling or transferring a property, for example, a company business also purchasing a property for an individual. So no amount of identity verification or customer due diligence will help when these are the types of money laundering methodologies or schemes in play. And the Financial Action Task Force report from 2013 on vulnerabilities in the legal profession looked at the different types of lawyer knowledge around money laundering risk and the actual involvement in money laundering. And this graphic taken from that report explains the different types of lawyer knowledge. And the research found that lawyer knowledge existed between two possibilities. It was neither complicit, neither unwitting. And that's the bit to be mindful of. Somewhere in between is where lawyers can be caught, unfortunately. And I want to highlight how innocent involvement is where there are no red flag indicators apparent, but it moves to unwitting where red flags are missed or the significance might not be understood. And this isn't a good place to be. And it is much better to be able to spot red flags before agreeing to provide a legal service if it is very high risk. And then this infographic, it splits off into deciding to provide a more high-risk legal service and making reports. Obviously, the most alarming aspect is the willful blindness, corruption and complicity where there are red flags. My colleague will shortly provide an excellent presentation on specific red flags relevant to the legal sector, and these are central to effective AML. As I said, you can't do AML compliance if you don't know what the red flags are. So I will be very, very brief on the red flags themselves. I just want to flag that if there is one place to go to expand your knowledge of legal sector risk and those money laundering red flags, it is that report I've just mentioned, the Financial Action Task Force 2013 report on vulnerabilities in the legal profession. It really is essential reading, and it's linked to and summarised on this particular slide, and it's evidence-based research of the risks and threats to the legal sector. Knowledge of these red flags will reduce your vulnerability to being used to launder money. And I can't emphasize enough the value in everyone who has a client-facing role in your firm, knowing the red flags so that if they come across them, you have the opportunity to assess those red flags before proceeding. There's a real opportunity there to prevent your firm from being targeted and also save headaches down the road. If you might have preferred to have disengaged had you been alerted to a red flag earlier. The next item that I'd recommend on the compliance checklist is to consider, have you evaluated your firm's vulnerability to being used to launder money? Once you understand how lawyers can be used to launder money, the next step is to evaluate that current threat to your firm. Known as the business risk assessment, this requires firms to take a bird's eye view of the risk exposure. It's a concept that has been there for many years now, and it's linked to policies, controls, and procedures, which are around even longer. And this is so important. It's a statutory duty which you need to fulfill, but it is a strategic step also because it is something which can help you see where risks might be and identify what you might like to avoid. It's an approach which ultimately will help reduce a firm's exposure to being targeted by money launderers. There's an opportunity to pick and choose more high-risk services, perhaps online, non-face-to-face instructions, and decide at a business model level these may be too high risk or too complex or too costly from an AML compliance perspective. And there are different ways to go about ensuring you comply with this duty to conduct a business or firm-wide risk assessment. You can start with a blank page. All of the different risk factors are here in this infographic that you need to consider. They're set out in the slide in terms of delivery channel, transaction type, geographic risk. Or you have the option to adapt a sample adaptable form developed by the Law Society, and it guides you through the issues you need to consider. No two will ever be the same. Every practice has different clients. They provide different legal services and in different ways. And ultimately, you need to have well-developed understanding of legal sector risk and the types of legal service you are open for business. Next, I'd recommend to consider whether have you put risk-appropriate AML policies, controls, and procedures in place. So once you have done your business risk assessment, you need to develop your policies, controls, and procedures which are risk-appropriate and relevant to your firm. This will help reduce your firm's exposure to money launderers and help you demonstrate compliance with the statutory duty to develop policies, controls, and procedures. And it's important to be aware that there are some very specific statutory duties around what policies, controls, and procedures need to address. Senior management approval, for example, and also keeping your policies and controls and procedures under review. They are at the core of this. Your policies, controls, and procedures are vital in firms because they help determine at a strategic level how AML regulated legal services are provided. They present a really beneficial opportunity to take the decisions about whether to provide certain legal services at all in your policies, controls, and procedures before you might even be targeted by a professional money launderer. Your policies, controls, and procedures need to outline controls, policies, and identify how risk is mitigated. For example, many firms refuse to accept cash, and others have very strict controls over the provision of account details for transactions to ensure they are happy with regard to funds before any money is even transferred. They also present an opportunity to outline and define staff responsibilities around AML and communicate to staff in firms that they must be followed. Policies, controls, and procedures need to be at the heart of every firm's AML framework, connected to the business risk assessment and helping determine processes for customer risk assessment and risk-appropriate CDD. They help move away from ad hoc CDD and really are very beneficial in helping to prevent a crisis in your firm. Next, consider, do you risk assess for money laundering before agreeing to act and gathering CDD? Now, moving away from the business and the firm-wide AML duties to AML on individual clients and matters where timing also is key. The purpose of CDD is to get you to ask questions, to get to know your client, but you won't know what questions to ask until you risk assess, until you start to look under the bonnet. So before taking on a case and proceeding, think about whether there will ever be a combination of documents which will remove the personal risk of committing the substantive offence of money laundering. Sometimes not necessarily suspicious, but the level of AML compliance might be too complex for a sole practitioner or a smaller firm, or indeed outside of their expertise. Risk assess as early as possible and throughout, as needed, to ensure compliance with client and matter risk assessment duties. Protect yourself and your firm first, and the compliance CDD will look after itself. Because once you risk assess, you'll be able to decide what CDD you need to verify the client story. It's always much more than identity verification documents. And this item is on the checklist to make sure really that you empower yourself to be able to spot when somebody might be trying to use you to launder money at the best time for you. Do not jump to collating documents or bank statements, especially where a potential risk exists. Don't make the mistake of seeing anti-money laundering as a way to stay safe. Remember, there is more to this than keeping a file in order. And AML, by its nature, it may be anathema every other aspect of your training and role as a lawyer. It goes against your core duty to clients and it reorients it on a statutory basis in some very specific circumstances to the state and changing lawyers into a form of gatekeeper. But that duty to client has always had to be balanced in the public interest. It has never been blind loyalty to clients. And it is a fact that the legal profession across the world is consistently being targeted by professional money launderers. And it is the case, if it is the case that a client could use you to launder money, anti-money laundering compliance may in fact help you. And in particular, the client and matter risk assessment, make sure you complete them before agreeing to act and engaging. Don't put the cart before the horse. Risk assess before you agree to take on a case. But what do you do when you spot a red flag, or there might be multiple red flags? First of all, focus on deciding whether or not you provide the legal service and what information you would need to try and find out if it might be possible for you to provide the legal service. And when risk assessing, again, it might be helpful to bear in mind a general rule also from the Financial Action Task Force 2013 report, and that is, if there are a number of red flags, it's more likely that a lawyer should be suspicious. And I think it's important also that it emphasises the need to consider red flags in context. So in practice, what you need to do is to ensure that you document your thought process around this to be able to demonstrate your thought process around it, how you considered any potential red flags to your regulator. And bear that Financial Action Task Force rule of thumb in mind, the mere presence of a red flag versus a number of red flags leading to a suspicion. If there is potentially one red flag, well, you might have some sort of knowledge around there being a potential legitimate explanation, and it'd be very important that you document that in your client or customer risk assessment and think very carefully before you continue, especially if there is more than one flag. The next item on the compliance checklist would be to ask yourself, have you adopted the traffic lighting red flags approach? You might find it helpful to start adopting this approach when you're risk assessing red flags in individual scenarios. And I designed this to help lawyers contextualize and risk rate red flags when they arise. It's here just to mention it to you as a really practical way to approach your AML, and especially when trying to interpret or risk rate red flags. My colleague will look at red flags in detail shortly, but once you've expanded your knowledge of legal sector risk, please come back to the traffic lighting approach. It's a color-coded traffic lighting system around the scenarios, some example case studies suggesting what might be very high risk in red, medium in orange, but with good CDD may move to standard risk, and standard risk in green. You really need to be careful if you're being asked to provide a legal service in circumstances similar to the red coded scenarios. And if you are interested in learning more, please go to the last half hour of the training in English on the amlforlawyers.eu website. And the second last recommendation is, are you documenting your customer matter risk assessments? This checklist item is here to communicate the importance of making sure you're capturing your compliance with the statutory duty to risk assess customers and matters. It's so vital to capture your compliance with this duty, and it's vital that you document your customer risk assessment to be able to demonstrate in the future to your regulator your compliance with the duty to risk assess clients, and also to demonstrate that the CDD you applied was risk appropriate. In Ireland, we have published sample adaptable forms to help lawyers document their compliance with this duty alongside a risk factor questionnaire. Over the years, these have become a key resource to help solicitors in Ireland demonstrate compliance with customer risk assessment during inspections by the Law Society of Ireland as their regulator. Documenting risk assessment, capturing it for regulators, it is essential to be able to demonstrate your compliance. Don't do all that good work of risk assessing and applying risk appropriate CDD and not then have it ready to show your regulator. And finally, do you engage with the due diligence, the CDD, as it comes in? Another key item to ensure your AML compliance is fit for purpose Make sure that you are engaging with the due diligence as it comes in. It's really, really important to do this. After you've agreed to take on a legal service, even if traffic lights are green and it is standard risk, it's important to ensure that a future potential red flag doesn't arise as you progress, or if it does, that you can quickly identify it. For example, if funding all of a sudden comes from somewhere unexpected, look at the due diligence that follows that initial risk assessment. Look out for last minute changes or substitutions. Checking back also to see are there new red flags, and document your thought process again around this. No one is expecting you to be Sherlock Holmes here, but you do need to interrogate the due diligence as it comes in. There is more at play than putting copies of documents on file. You need to think, are you happy that things are happening in the way you were originally told by your client they would? Does what's coming in dispel any concerns or provide or give you that comfort around the legitimate explanation you might have been told around a red flag? Remember, sometimes money launderers will know what to say to get past your onboarding systems, to get you to provide a legal service, and then it is up to you whether or not you are engaging with the due diligence as it comes in. And it's always very possible that someone could be testing the AML controls that you've put in place. So the AML compliance checklist, I think, and I hope that by working through just these 10 questions, any small firm will have a solid AML compliance program in place. And the goal of that step-by-step checklist is to help make sure, number one, your AML compliance is fit for purpose. 2, it meets your supervisor's expectations. And 3, most importantly, it helps reduce your firm's vulnerability to being used to launder money. Thank you.
Thank you so much, Emma Jane. Thank you. And there are a lot of questions, but maybe not all of them are for you. One of them definitely is. Svetlana Koleva says that you raised several times the risks related to litigation schemes, even though litigation is out of the scope of the AML directive. Do you refer to it only due to the risk-based approach being applied, or is there any legal basis for treating litigation representation as a potential red flag?
So many, many years ago, I think it was probably around 2010, professional money launderers must have realised that AML regulated legal services applied to certain services, and looked whether there might be an opportunity to target firms outside of that. And what started to be created was fake and fraudulent litigation, where someone would contact a firm and say that they needed a debt collection, or there might have been a family law collaborative agreement in another country that they wanted enforced. And there's other red flags that appear. It's, if you look at the slide that's there, I think scenario 1 is specifically around the traffic lighting red flag slide, is around this particular fraud. And it's less about the AML compliance, more about the risk of the substantive offence of money laundering, because ultimately it's less of litigation. Somebody's trying to get a lawyer to handle funds at the end of the day, but it first presents itself as a litigation. So it's about people testing the compliance programs that you have in place. And really the best way to avoid it is to just always have those red flags at the back of your mind, and always be thinking if something makes sense. And the thing with these particular scams was that they settled without any legal work really needing to be done.
Okay, thank you. Some of these, I'm going to ask Claudio to come on screen only because some of these came when he was speaking, so they may be for him as well. I don't mind who answers the questions. So we have a question saying, when we receive work from another law firm in Europe or the USA, shall we do know your client for the law firm and the client?
I think, yeah. Sorry,
I'm sorry. Emma, please go ahead.
I think it depends on the nature of the legal service and the extent of the instruction. Again, it always comes back to no formulaic approach, and no two legal services being the same. Sometimes it could be a red flag, sometimes it might not be. But it's always important to really know who your client is. And I would, from a risk perspective, encourage people to make sure the instruction is coming from a client directly. Claudio, what do you think of that response?
No, I agree, Emma. Of course, you're right. We need to answer the question in an holistic way. You're right. Formally, your clients has to be done on the client, which is coming in, not on the lawyer of the client, which maybe is referring you the work. So in strict legal terms, the answer would appear to be no, you can skip. And to a certain extent, the answer is strictly no. However, to do a good know your client approach with the client, you also need to pass, on the lawyers who's advising the client. Who are they? What type of legislation, whatever expertise they have. So in a certain way, the answer is more holistic. And as you said, Emma, it depends.
One last question before we move back to you, Claudio. Niels Grove Jensen says, Denmark publishes lists of PEPs, exposed person. Do any other countries do this so it's easy to check for this status? Or do you know of any providers who collect and publish this information?
I think that there's a lot of people would commercial providers of screening tools, that it's not just the PEPs, it's much more than just PEPs. And I think it raises an important point as well in terms of sanctions. It can be very helpful, but these things can be expensive. Individual countries have approached it differently, but it's something PEPs is really important for all lawyers to be aware of, to be asking clients, even if they might be a PEP or they might be connected person to a PEP as well. And because it's so important to make sure that the due diligence, the extra enhanced, it's not there to prevent the provision of legal services to PEPs. It's an really important anti-corruption measure that's there. So it's important to have a way of identifying a client might be a PEP. And it's just about getting senior management approval and ensuring it's enhanced inquiries around source of funds, which is really much more about evidence around source of wealth.
Right, Claudia, we come to you now. I've asked you to look at the questions, Claudio, and if you're able to answer some of the questions as you're going along, that's great. If they don't fall within your presentation, don't worry about it. So we come now to Claudio returns on the application of legal professional privilege in the context of AML obligations. Claudio, please.
Jonathan, do you want me to try to respond quickly on the questions on the
Yes,
chat,
very quickly. Yes, I'm very happy if you do that. Go ahead.
So if I go on the first one on the chat, on the Q&A, one question is interesting, asked on Article 70 and the difficulty and the challenge in interpreting it. Now, in the sense that the exceptions to the exemption might require intrusive examination. Now, you're right. However, be aware, and we included this wording in the letter C. It is written that the knowledge or purpose may be inferred from objective factual circumstances. So the knowledge of the clients being criminally intended and so on must be objective when it comes to an analysis for the lawyer behavior. So we have included in the wording a protection of your concern. The second question regarding are we concerned as to whether as to the implementation of Article 70 when it comes to the third paragraph and the possibility to expand the exemption? Yes, we are. We are concerned. We need to be vigilant to that. The question by Leonard Pivek on the AML providing exemption in terms of the lawyers being individuals, not law firm. No, it does not provide. All lawyers are both being in law firm or just practicing individually are included in the AML regulation. Then there is another one regarding, yes, good morning. Yeah, ISIS, these are the more relevant that were on the list. So if Jonathan allows me,
Yes, please go ahead.
I would
go
get
ahead.
on the legal privilege presentation. Jonathan, I have how much? 15 minutes, 20 minutes? Could you remind me of the clock?
Yes, so you have until 45 you end, and since there may be more questions to 40, so that means roughly 15 minutes. If you could do 15 minutes and maybe more if we have...
All right, so do alert me when I reach the 15
Thank
clock. Please, the legal privilege is a cornerstone of our profession. And what I would like really to share with you today is a very brief overview of certain provisions covering it. But also I would like to focus on two peculiar recent cases of 2022, which gives us a bit of leeway when it comes to maybe a new revision, maybe a new thinking, maybe a new case law at the horizon when it comes to a legal privilege and anti-money laundering. Let me try to share the screen first of all, and I hope I'm in there. Yes, I am. First of all, provisions. The provision covering legal privilege are scattered, are in the Charter of Fundamental Rights of the European Union, Article 7, Article 8, are in Article 41 when it comes to the confidentiality and the professional and business secrecy. We find reference to confidentiality in the right to a fair trial in Article 6 of the Human Rights Convention. Article 8, privacy pillar, when it refers to the that must be no interference by public authority when it comes to the private correspondence. We have a directive covering confidentiality. We also have, of course, our ethic codes, both the European lawyer provision of the Code of Conduct and every EU country national ethic code. I like to read with you briefly, or just look on slides, the precise, elegant, eloquent wording of Article 2. It is of the essence of a lawyer's function that that the lawyer should be told by his or her client things which the client would not tell to others. Confidentiality is therefore a primary and fundamental right and duty of the lawyer. A lawyer shall respect confidentiality of all information that becomes available to him or her. So, very eloquent, very clear. It is of the essence of our function. And this core, this principle is indeed present in all national codes. Article here in the slides, you see also Article 22 on the United Nations. And as I said, each national legal system provides for special rules. Now, here I'd like to pause for a second and first of all, suggest to you an interesting reading, which is a reading, of a former chair of CCBE, Judge Mr. Edwards, who was a Scottish judge who was a president of the CCBE and then a judge of the European Court, who provided in the 70s and 80s a very comprehensive work of comparative legislation on professional secrecy throughout Europe. That document is present in the CCBE website, is updated recently. It provides an overview of how different legal professional privilege provisions are throughout the European Union. Now, I said the word different, but I, of course, need to correct myself because, yes, there are differences. In France and Italy, it's a duty that cannot be waived. There's a public element to it. In common law jurisdiction, Ireland, for example, or UK, most likely confidentiality in certain instances can be waived by the lawyer with the authorization of the client. But the bottom line that all these differences tell us but one thing, that the hardcore of the provision is there, which is the function that we said before, the essential function for a lawyer to serve, not to serve for access to justice and for litigation when it comes to citizens asking for access to justice and litigation. Here, of course, we have several EU cases, AMS, I'm sure you've read it, and also Wouters, an important case. The European Court, when it came to the question as to whether the new European legislation introducing the obligation of lawyers to file suspicious transaction reports would trigger and would be in line with the provisions covering confidentiality. When it came to these questions, the European Court in 2007 said no. Said very clearly that the provisions that we have just read before during my presentation regarding the obligation of notaries and lawyers to file is in line with European law. We fought very strongly in the attempt to defend professional secrecy. But the court stated that, the directive which was introduced does not infringe ultimately the right to a fair trial. And that ultimately, therefore, since there was an exemption for lawyers not to file STRs, as we've read it before, when it comes to the preparation of and the assistance of clients in the course of the litigation, the fact that this would not impinge or affect that would satisfy the court that a right balance was struck, and therefore that the provision in directive is valid. And has been valid and is still valid, this jurisprudence until today. The battle of defending legal privilege in the context of the role and function of lawyers has been lost when it comes to anti-money laundering. Has been lost in Poland, has been lost in France, has been lost in Italy, also at national level in many cases that have adhered to the case law of the European Court of 2007, which I cited just before. We therefore came to terms, and we have come to terms with the complex, delicate balance of being loyal to a client, but also needing to be loyal to the system, to the rule of law. And it is in this dual complex set of obligations that is the beauty and complexity of our legal profession, no doubt about that. Now, let's get on the point of these two case law that I wanted, two cases, European Court cases that I wanted to cite and share with you. These are very recent. One is pertains beneficial ownership, and the other one is on DAC 6. Let me start with DAC 6 because I don't know how much time I have left, and I'd like to focus on that. Now, what is DAC 6? DAC 6 is the directive which has been implemented. I'm not a tax lawyer, so I would say very abruptly and probably not technically sufficiently precisely, and I apologize in advance, but bottom line, it introduced the obligation on lawyers and on other professionals to communicate to the authority when it comes to certain aggressive tax schemes that clients are carrying out. So it is an obligation for professionals to communicate to authorities that something might go wrong, more or less similarly to when we, on the basis of the AML legislation, are obliged to issue and file STRs when we see a red flag or when we have a suspicion. Now, in this context, so in the text arena, and in the area of this specific directive, the court defended lawyers and defended, I'm making a mistake here again. It's not defended lawyers, it defended citizens. It defended the rights of the citizen to be freely and fully protected when it comes to the advice the citizen receives from the lawyer. So if you read in the slide, it's an important case because basically it says correctly so that lawyers would be unable to carry out satisfactorily their task when it comes to, and could be deprived of the rights conferred on them by Article 47 of the Charter, when lawyers are obliged to cooperate with authority by passing information obtained during the course of legal consultation. Now, it is, I think, an important novelty because it provides wording in the context, in the direction of a renewed, revised, rethought, maybe so, understanding of legal privilege and confidentiality by the European Court. Is it sufficient to say that this is a turnaround and we should go back and fight against AML and STRs and the confidentiality affected and broken there? I don't think so. I don't think that that provisions and that angle and that jurisprudence will change. But notwithstanding that, I believe that this is an important and relevant case to remember, also at national legislation when it comes to discussing, defending, understanding the role of lawyers and the importance of confidentiality. So December 8th, 2022. Very quickly, the Luxembourg case of November 2022 is not directly on confidentiality of lawyers, but on privacy at large and in general when it comes to beneficial ownership registers. It's interesting because basically it established that certain provisions in the Luxembourg beneficial ownership registered, and when it comes to the implementation of the legislation by Luxembourg, was not correct. Because they were open to everybody. I will leave it in these very general terms, and therefore there was no guarantee of protection of personal data. It's a very complex set of provisions. I will not get into that. I only want to point out to your attention that, again, here, privacy and understanding of private elements, so delicate and important, need attention, need protection, and the court also granted, an open, if you want, light and share light on the importance of Articles 7 and 8 of the fundamental rights of the European Union, which indirectly also cover confidentiality. Other cases are here cited. I will not comment on them. Last, this one on the European Court of Human Rights, a Turkish case on by Turkey. It's interesting. I conclude with one case which is there to remain as an interesting one, because when asking the question, which country has fully and totally protected client-lawyer confidentiality when it comes to anti-money laundering, by basically impeding lawyers to make at all cases STRs, this is Canada. The Canadian lawyers have been fighting very, very hard in protecting the confidentiality provisions. And indeed, in 2015, a very interesting case by the Supreme Court of Canada assessed that the legislation on money laundering, when it comes to imposing obligation on lawyers to file STRs, is unconstitutional. So it's an interesting case because it explains and it, if you want, allocate the importance of the function of being a lawyer and the function of correctly understanding and applying confidentiality as an essential and important pillar of the legal profession. I have concluded, Jonathan. Maybe I went a bit quicker than
You did exactly as instructed, Claudio. Thank you.
I am a very compliant. I am an AML compliant person.
You are. And there are no questions arising out of your presentation. I would just point, so if you want to speak for another minute or two, I'm very happy to. I just would point out to everybody that in the chat has been put the link to the registry, the Boris registry, the beneficial ownership registry, which was mentioned by Constance earlier, and it's been put in the chat by Anna Spolinska of the CCBE. So for those of the participants who want to see the link, it's there for you. You have a couple of minutes left, or we can go to our next session, which is which was time deprived in a way. So if you're happy with that, Claudio, I thank you very much indeed for your timeliness.
Absolutely. Please, let's hear Arne and what he has to say. Thank you.
Yes, very good. Okay, Arne, I hope that you are ready for us. So we move on to our last, and last is by no means least, because the session which we're about to hear from Arne Engels, who is a member of the CCBE's Anti-Money Laundering Committee, a German lawyer who's a specialist in banking and capital markets law, is what to watch out for. Money laundering, red flags. We've heard about red flags already. They really are a crucial part of money laundering. So Arne, over to you, please.
Yeah, Jonathan, thanks a lot, and thanks a lot to all of you participating today. So hopefully everything works out. So let me start a little bit also with my presentation. I'm very happy to share this, and Emma already mentioned lots of red flags. So let's go a little bit more deeper inside these issues. Well, there we are. So this is who I am, but as we have seen, we have heard lots of topics today, and most of you will have such a hat like this person on the screen. So let's go a little bit more smoother. And like Jonathan already mentioned that you can get the slides later on. So very happy to share everything. We all know the best is always at the end. And now we are doing a little bit about red and yellow flags, more or less about red flags. Emma J mentioned already the traffic light system, which is a very good one. So I can only encourage you to use the traffic lights more than this flag system, because it's very much you might be needing about. You need to be aware of a few things. The most important thing to know about money laundering prevention, and Emma mentioned it a very strict way already, you should be very very keen in following up what's your impression. So if you have a bad feeling about the client, about the story, about everything you hear from clients, or I could tell you some example cases about this, they should be aware of that there might be lots of risk. So the most important factor in preventing money laundering and terrorist financing is you. Just be aware of that fact. If you are doing as a lawyer, the opening, that you are allowing the people to enter the legal system, to use the legal system, we are getting the same problems that we have now. And Claudia already mentioned that we have lost the professional privilege, in most of the cases already, to the new legislation. Please be aware of it, that the secrecy is very hard. We have fought for it for ages, and now we are losing it. So be aware of it and be very careful. We have seen that there are a few types of services that are vulnerable to money laundering. Of course, everyone knows purchase of real estate. Real estate is one of the biggest issues, especially the German market is one of the biggest ones we have in the European Union. And the figures are telling that half of the amount that is spent in real estate in Germany should be done via money laundering. I'm quite sure that's not the case anymore, because we have strengthened the legislation very much, and we have also included a few more provisions into this one, but nevertheless, lots of things are going through real estate. Sham litigation, Jane mentions this regarding the question. We have seen this lots of times, fake litigation. That's a big issue we need to be aware of. Use of clients' accounts. Yeah, that's always an issue. Please be aware of that. The clients might be trying to use your accounts for making payments. So every time the client wants to use your trust accounts, be very careful what's happening here and why it is happening. We'll get to it a little bit later. Management of trust companies and charities. We all know there's lots of money inside, and we have seen, especially in the time of October, November last year, that charities have been used or misused again for terrorist financing. So that's one of the biggest issues we always need to be aware of. Where's the money coming from? Where's the money going to? And where should it be used to? Creation of trust companies and charities, that's the other thing. We need to be very aware of that we might be used for creating only these things. And especially if you have a specialized law firm like we have, which is a full service law firm, we are very wondering if a client only comes to us for the creation of something and not for the ongoing business later on. Because there is always a hint, why is he buying the company from us? He can be buying the company from other sources as well. So that's one of the biggest issues we should be aware of. Why is this company used to? If a person comes and wants to have, for example, 5 companies at the same time, just be aware of it. There might be a risk. Please check all these things. So we are facing geographic risks in general. Of course, we have lots of sanctions these days issued by the EU and the UN. We have seen this, Jane mentioned already the sanctions topic. It's very much more severe than it was 5-10 years ago. So be aware of that. We are not allowed to provide special legal services in some cases. Please check the European directive in this ones, and be aware of it. There are lots of things. Countries identified from the FATF or from other sources that might be lacking the high risk, so-called high risk countries. Be aware of if the party is coming from or money is sent from these countries. We should be aware of that there's a risk included. Sometimes You have the national risk analysis that might be adding some other countries as well. So be aware of, there might be not only the official ones you can see on the FATF website, but also or on the EU website, but also please check your local websites. Service risks. I've already mentioned financial intermediaries. That's nothing what we should do in a usual way. Service requests by clients, we don't usually do. That's always some things where we should be aware of that something happening. If you are selling a property that has been only sold to the person that is approaching you now, that's also very much a big of a risk. There might be lots of issues, including why it is happening now. Why are they selling? In Germany, we have a suspicion, generally suspicion if it's less than 3 years. But also 5 years, usually you don't buy and sell houses or real estate properties. There might be exemptions, of course, in any case in Germany or in Germany. One of the biggest cases is now within one of the biggest insolvencies we have, which is an Austrian company, and they have lots of real estate bought within the last 5 years, and this is going to be sold now again. But there you have an exemption, there you know why it is happening and why you can do it. So please, it's a red flag, but as Emma Jane already mentioned, and I can only appreciate that one, because you have to be aware of there's always the special case. So you have to look into every case individually. There's no general rule that's not be able to do so. There might be general risks coming from the client. We have heard about the PEPs structure. We all know corruption is still an issue in lots of countries. So if there is a political exposed person, please be aware of it. That might be still a risk. If the relationship of the clients makes it difficult to identify UBOs, if they're not providing all the documentation, that's always a big of a risk. What's happening here? We see that lots of companies have problems having these structure available because it's very much complicated. But the better ones are aware of this one. They have specialized departments, even within their group, to provide all the documents needed. So that's a big issue where you can do lots of things. Charities, non-profit organization. We have seen this for a long time. There's going to be a risk with lots of them. So be aware of what are they doing and check them a little bit more. If you don't find them in the internet, if you don't find proper documentation, what they are doing, who they are financing, what have they done, where the money has been going to, provable, then you should be very careful. Use of financial intermediaries, we have already seen this. Lots of times it's big of the issue where the client is coming from. If you have, for example, cash-intensive businesses, be aware of where we have still lots of cash around, so money can be used for this one. Another big hint might be if the address the client has is used for multiple from multiple companies. So it might be a company that's not really working. It's just a company which is a postbox company. So be aware of what's happening over there. You can check these addresses usually via the search engine on the internet very easily. How many companies are registered at that address? If you are aware, which is also very much happening in some clients, that they are changing the direction, that they want to have A first, coming to you to provide services towards A, and then they want B, which is totally different. That's always something you need to be aware of. And of course, if you have already prepayments, and they want to have it back, please be aware of this one as well. Client's behavior, that's the last. We've already mentioned the instructions are changing a lot. But also if you have a bad feeling, he's not telling you something, the source of money is somehow suspicious, you don't really understand what's happening over here, and the transaction is not done the way you would usually doing it, that's one of the biggest issues as well. So you need to be aware of this. It's a guts feeling usually. So we had one case where a student came to our law firm, wanted to buy an apartment in one of the German cities in cash, and usually students don't have so much money. So please be aware of that you have to do what you have to do in this issues, STRs, and everything else. The client, if you've done some report or background check about your client, which you can do usually via lots of databases, and if you know that there have been convictions is somehow associated to a political exposed person, that's really high risk transactions usually, whatever, please be aware of that there might be risk, especially if the person knows exactly for no real reason what's happening inside your company, why you should need to do things, why you need to be aware of where are the borders to have an STR. Emma Jane already mentioned that the criminals usually are trying to check whether you are doing things or not, how you are reacting. And that's something they are doing with lots of law firms. So they have a balanced approach. Who might be a good law firm to work with later on, which is usually the one who's weak in AML. So be aware of these things. Concealment techniques, we have mostly already mentioned them. Use of false or counterfeit documentation. If you don't see the business on the internet, if you don't get proper information about it, that's always a big issue. Usually the better criminals are already faking the websites, so you can find them at least somehow in the internet for some times. If you have the opportunity to do a who is research, usually the company says it has been founded somewhere ages ago. There should be the domain already registered ages ago, because usually there's no need for having a new website within 2 weeks before asking you about service. So use everything you can do about these things at all. As you see, there are lots of red flags. We have not the time to speak about all of them today, but we are trying to mention a few of them. So please be aware of the age I've already mentioned, current business reason. If they're approaching you, you don't really know where they're coming from. If they're coming from a third country, why are they doing it? Please be aware of this. Funds, we have mentioned already, no legitimate explanation. There are lots of issues where you should be aware of. One thing always needs to be checked: is the money coming from the company who's your client? Is the money coming from the country your client is residing from? If not, please be aware of there could be additional risks as well. Source of funds is unusual. So we have seen this. If they are splitting your payments, if they are sending it from various accounts, there might be always a good reason to look into it. So used as collateral for a loan. So we have seen lots of issues. And I see already, Jonathan, so I have to finish. But no, there has been a lot. And usually, I hope your head is not exploding by now. If you have further information, please feel free to contact me. And thanks for everything. Jonathan, I'm open to any questions you have.
Yes, and that's why my picture appeared. There is one question, which is actually a general question. I'm not sure related just to you. You or anybody can answer, from Marlene Sippel, who says, is there any entity from the EU available to provide support to lawyers in case they have doubts in regard of the appropriate diligence to be adopted in a concrete case? I will partly answer this. I mean, your bar should have some kind kind of support, and I mean, I think that's what Emma Jane Williams does in Ireland, to provide that support. But is there any EU support for lawyers?
Passing this question to Claudia, because I'm not aware of this.
No,
I'm
I'm
only
not
aware
either,
of
Claudia.
everything
No,
at my bar.
I would say the short answer is not directly, not really, and therefore we will have to recourse directly to the resources and the sources that have been cited by Emma, by me, by Arne, and also refer to, when possible, to the hotlines and the activities that local bars have and carry out all throughout Europe. And very often there are hotlines, for example, Jonathan, of local bars responding quickly to AML questions for practitioners. But at EU level, no, there isn't an entity that I'm aware of.
No, thank you, Arne, thank you, Claudio. And as Emma Jane pointed out, I mean, there are reports by others where many questions, the CCBE, ABA, IBA document has many answers to questions. So there's the resources which have been cited, which you will also receive when the slides are put up on the website, will help you answer. Thank you. We have precisely arrived at our end. I would really like to thank all our speakers. I will give a symbolic round of applause on behalf of all our many participants. Thank you very much for your excellent presentations, for answering the questions. Thank you also to our participants. We hope you will come to future webinars put on by the European Lawyers Foundation. This is the end. I wish you all a good day. So thank you very much, and goodbye to you all. Bye.